A class action has been launched on behalf of Canterbury earthquake claimants feeling like they've had a raw deal from Southern Response. The government-owned insurance company was responsible for settling claims by AMI policy holders, but a lawyer says hidden costs led to about 3,000 people being underpaid. Katie Todd reports.
In 2011, Christchurch homeowners Brendan and Colleen Ross approached Southern Response to get a detailed repair analysis, or DRA, for their earthquake-damaged house. It gave an estimated cost of repairs, based on which they opted to buy another house. But Mr Ross later learnt the DRA they were given was an abridged version of the one their insurer got, leaving out one page of costs.
Unknown to us, there was separate costing that we became aware of later on after we went through the Privacy Act and got our details from Southern Response. There was another DRA in effect that we never saw.
And so how much do you think that would have cost you?
The difference was about, in our case at least, 140,000.
Ross Williamson and his wife Ellie faced a similar situation in 2012.
We were so worried about a settlement to get out of Christchurch in a hurry. Our health was suffering and we had to get away from the liquefaction. When we found out they did all this out of 130,000, we were quite upset.
In 2014, the matter came before the High Court and Southern Response changed the DRA process. But Christchurch lawyer Grant Cameron says the Rosses and Williamsons are among about 3,000 people who settled but never received compensation, and he estimates about $300 million is owed. This morning, Mr Cameron announced he has the backing of Australian law firm Morris Blackburn, who are taking class action to recover the money. Mr Williamson says it's great for people like himself and his wife, who couldn't afford to face Southern Response alone.
It's finally got the ball rolling, and as I say, we've been on tenterhooks. First of all, we thought not a lot was going to happen, and after 5 or 6 years you'd tend to think that, wouldn't you?
Grant Cameron is inviting any other Southern Response policyholders who settled before October the 1st, 2014, to join the class action. He is confident people will recover their missing money and hopes it will be a relatively quick process.
Many class actions, unfortunately, do tend to be protracted. There's a lot at stake, there are a lot of complications, and matters can drag on for a long period of time. However, in this case, everybody has settled, and this government is far more motivated to sit down and look at reasonable ways of resolving it. So my personal expectation is that it may be a matter of months rather than a matter of years.
The class action is happening on a no-win, no-fee basis. Claimants don't know exactly how much they will lose if it's a win, but expect lawyers could take a cut of about 20 to 30%. University of Auckland law lecturer Nikki Chamberlain says class action can provide access to justice when it is otherwise uneconomical or inefficient. But she says people taking part need to check it's the right option with the right boundaries in place.
I would suggest that anybody who is thinking of looking into any class action to carefully review the litigation funding agreement to see if they are happy by which the terms of that agreement.
Checkpoint approached Southern Response for comment, but a spokesperson declined. As the case is currently before the courts, they say it would be inappropriate to comment at this time. Grant Cameron says he is looking forward to seeing the case through to its completion. In Christchurch, for Checkpoint, Katie Todd.